Good evening, everyone, and welcome to a conversation with Associate Justice Ruth Bader Ginsburg of the Supreme Court of the United States. My name is Neil Siegel, and my most relevant credential this evening is that I'm the father of two of Justice Ginsburg's grand clerks, Sydney and Dylan Siegel, who are very unhappy that this event could not be scheduled at a time that was more convenient for them. Justice, they're both at camp, and I would expect to hear from them both to arrange a play date at a mutually convenient time. I'm also the David W. Eichel Professor of Law and Professor of Political Science at Duke Law School, where I direct the law school's DC Summer Institute on Law and Policy. And the Institute has two main purposes. The first, to expand the pipeline of young people attending law school in an effort to diversify the legal profession. And second, to enable students around the nation and indeed around the world to try law school before they buy law school by taking introductory law school classes with current Duke Law faculty here in the nation's capital each summer. And the Institute has existed now for 7 years, and for each of those 7 years, Justice Ginsburg has given generously of her time and her mind by joining us on this occasion to share with her thoughts on the most recently completed Supreme Court term. Justice Ginsburg is one of those rare Supreme Court justices who was already famous and had earned her place in history by the time she was elevated to the Supreme Court. And she did it by insisting on a proposition whose simplicity and truth was neglected for most of American history. And that was the insistence that women and girls too count in constituting the people in whose name the Constitution purports to speak. And as I was walking to the podium with the Justice, I just received a note from my daughter. It was actually a note to Justice Ginsburg. And this is what she said. She said, I wish you the best of health so you can continue to inspire small girls with big minds and hearts who need someone to look up to. Thank you again for your true generosity. I hope to see you soon. And I don't think Sydney's alone in thinking of Justice Ginsburg in that way. And so, Justice, I've said it before, and I'll say it again, thank you on behalf of the entire community of Duke University. Thank you for honoring us with your presence here this evening.
Thank you, and good evening. Are there additional chairs we could get for the people who are standing in the back so they don't have to stand during this entire proceeding?
I think just your chair.
I'm going to start out with words that I didn't plan when I accepted this invitation, and they are what I said yesterday at the funeral of Justice John Paul Stevens, a man I love dearly. In the last week of his life, Justice Stevens attended a conference in Lisbon. As the next eldest in attendance, I had the good fortune to ride with him on the sometimes long drives between our meeting place and museums, vineyards, castles. His mind remained vibrant at age 99. En route, he spoke of court cases, even footnotes in opinions, his military service in World War II, ball games he attended. His conversation was engaging and his memory amazing. Let me get this. At the Lisbon conference, characteristically, just as at oral arguments in the Supreme Court, Justice Stevens did not speak often, but when he did speak, his wise, witty, admirably concise words drew everyone's attention. Perhaps he knew that at age 99, distant travel was a risk, but he wanted to experience fully the joys of being alive, and he did just that almost to his last breath. As we were leaving the U.S. Ambassador's residence our last evening in Lisbon, I said to John, "My dream is to remain on the court as long as you did." His immediate response, "Stay longer." A main theme in Justice Stevens' writings, the concept of equal justice under law requires the state to govern impartially. He viewed impartial governance as the most fundamental obligation of all public officers. As to judges particularly, he cautioned against decisions based on habit rather than analysis or reflection. The essence of the judicial craft, he said, was to exercise careful, reasoned judgment. He exemplified impartiality by his own readiness to listen and his respectful attention to opposing views. In a capital city with no shortage of self-promoters, Justice Stevens set a different tone. Quick and incisive as his mind was, Justice Stevens remained a genuinely genial, unpretentious, modest man. No jurist with whom I have served was more open to what he called learning on the job, more sensitive to the well-being of the communities law exists or should exist to serve. He was a model of independence, nonpartisan comedy, graciousness, and good humor. Justice Stevens had great affection for Justice Souter, who often dined with Justice Stevens and his wife, Marianne, enjoying Marianne's skill in the culinary arts. So I called Justice Souter and asked him to tell me some of his fondest remembrances. Justice Souter spoke less about Justice Stevens' path-marking or prescient opinions. There were many of those. He spoke more about what fun it was to be in Justice Stevens' company. Justice Stevens gave up piloting small planes in his senior years, but he remained an avid golfer, swimmer, bridge, tennis, and nimble ping pong player nearly all the days of his life. Justice Souter recalled encountering Justice Stevens, then aged 98, just returning from 9 holes of golf. Stevens acknowledged that, energizing as the game was, his drive just wasn't as good as it used to be. Or another time, when Justice Stevens and Justice Souter pulled into the court's garage at the same time, around 9 a.m., Justice Stevens was still in his tennis clothes, the clothes he wore for a 7 a.m. match. Justice Souter asked about the match. Justice Stevens, who had just completed a fatiguing course of radiation for prostate cancer, literally jumped up and down and exclaimed with glee, "I beat the pants off him." In a letter applauding Justice Stevens on the 30th anniversary of his appointment to the court, President Gerald Ford commented that Supreme Court nominations are seldom considered when historians assess presidencies. Let that not be the case with my presidency, Ford continued, for I am prepared to allow history's judgment to rest, if necessary, exclusively on my nomination of Justice John Paul Stevens to the United States Supreme Court. I am among legions of lawyers and judges who would concur heartily in President Ford's praise for the dignity, intellect, and absence of partisan political concerns that marked Justice Stevens' service on the court and to the country. Justice Stevens much appreciated the writing of the literary genius known by the name William Shakespeare, and I say that because Justice Stevens was a great partisan of the school that thinks the Earl of Essex was really the man we know as William Shakespeare. So I will end with a remark, with a line, a famous line from the Bard. It fits the prince of a man that Justice Stevens was. Take him for all in all, we shall not look upon his like again. And now, as Professor Siegel told you, I'll give you a quick resume of what the October 2018 term was at the court, the term that began the first Monday in October. At the end of the preceding term, in June 2018, Justice Kennedy announced his retirement. It was, I believe, the event of greatest consequence for the past term and perhaps for many terms ahead. For the first argument week of the term, we sat with only 8 justices. We could quickly regain full strength in the term's second week, immediately after Justice Kavanaugh's confirmation. With Justice Kavanaugh's arrival, Justice Gorsuch cheerfully relinquished to our newest colleague the special task assigned to the junior justice, answering the telephone the rare times it rings during conference, opening the door when an aide appears, usually to deliver papers a justice left behind. Then, and most daunting, conveying to the entourage from the clerk's office, the public information office, and other court administrators the dispositions reached at conference. Also, the most thankless of all junior justice chores, serving on the court's cafeteria committee. Justice Breyer retained his title this term as the justice who speaks the most words during oral argument. Justice Sotomayor ranked a close second. Justice Thomas, who ordinarily asks no questions because he thinks the rest of us ask too many, broke his silence for the first time since 2016, asking 3 questions in a single argument, Flowers against Mississippi, a case that challenged a prosecutor's jury selection practices as racially biased. Justice Thomas later authored a dissenting opinion in that case, in which the 7-justice majority held that a defendant's capital conviction could not stand. A combination of facts and circumstances, the majority observed, demonstrated that race discrimination in jury selection infected Flowers' most recent trial. A key consideration in the court's judgment was the prosecutor's history of exercising peremptory strikes against African American potential jurors in Flowers' previous trials. Justice Kavanaugh made history by bringing on board an all-female law clerk crew. Thanks to his selections, the court this term had, for the first time in history, more women than men serving as Supreme Court clerks. Women did not fare nearly as well as advocates. Only about 21% of the attorneys who presented oral argument this term were female. Of the 34 attorneys who appeared more than once, only 6 were women. Over 6,000 petitions for review were filed this term. We issued 68 opinions in argued cases, and to that number, one should add 5 summary per curiam decisions, opinions that were rendered without full briefing or oral argument, just on the basis of the petition for review and the brief in opposition. And that yields a total of 73 decisions rendered with opinions this term. Of the 68 decisions in argued cases, 20, or just over 29%, were resolved by a vote of 5-4 or 5-3. Among those same 68 decisions, we were unanimous, at least in the judgment, 26 times. So the takeaway is we agree considerably more often than we sharply divide. On the next to last hearing day of the term, we heard argument in one of the term's most momentous cases, Department of Commerce against New York. Secretary of Commerce Wilbur Ross decided to include a citizenship question on the 2020 census questionnaire. He said he was responding to a Department of Justice request for citizenship data to aid in enforcing the Voting Rights Act. Census Bureau analyses predicted that adding the question would depress the census response rate for non-citizen and Hispanic households, resulting in poorer census data. Evidence from the Department of Justice showed that Ross had sought inclusion of a citizenship question long before the department's request for that inquiry. Several states and non-governmental organizations challenged Secretary Ross's decision as arbitrary, capricious, and contrary to law in violation of the Administrative Procedure Act. Plaintiffs also asserted that addition of the citizenship question violated the enumeration clause contained in Article 1, Section 2 of the Constitution. After trial, in a meticulous opinion by Southern District of New York District Judge Furman, an opinion that spans almost 200 pages in F. Sup. 3rd, the district court ruled for the plaintiffs on their Administrative Procedures Act claim. The court accordingly enjoined the addition of a citizenship question to the decennial census. Presenting the case to the Supreme Court, the government urged the need to print the census forms by the end of June 2019 was compelling. It therefore asked the court to take up the case immediately without awaiting Court of Appeals review. The Supreme Court benefits from the decisions of the federal courts before the Supreme Court, district courts, and then courts of appeals. But this time, the government said the need for a decision was urgent, so we complied with their request to skip over the Court of Appeals and took the case directly from the district court. The Supreme Court's opinion, authored by the Chief Justice, affirmed the district court's conclusion that Secretary Ross's stated reason for adding a citizenship question was pretextual. The Secretary's representation that the question was needed to aid in the enforcement of the Voting Rights Act, the court said, appeared to have been contrived. Accordingly, the Supreme Court upheld the injunction against including a citizenship question on the census form. Justice Breyer, in an opinion I joined, along with Justices Sotomayor and Kagan, would have affirmed as well the district court's determination that the Secretary's stated rationale could not support the question's addition, even if that rationale had not been disingenuous. Next, I will describe some of the other headline cases heard during the 2018 to 2019 term. In Gamble v. United States, the petitioner asked us to end the separate sovereigns exception to the double jeopardy clause. Under that exception, separate prosecutions for the identical offense do not constitute double jeopardy if the charges are brought successively by a state and the federal government. Under the exception, it is irrelevant that the second prosecution would have been barred had it been instituted by the same government that brought the first prosecution. Gamble was prosecuted and convicted under Alabama law for possession of a handgun by a person with a prior conviction for a crime of violence. Despite the state prosecution, Gamble was indicted by a federal grand jury on a charge of possessing a firearm by a convicted felon. Gamble argued that the federal indictment should be dismissed and the separate sovereigns exception abandoned. His position: the states compose one federal union. Parts of that union are not separate from the whole. Gamble's argument persuaded me, but not the court's majority, which preserved the separate sovereigns exception by a 7-2 vote. The next case I will describe is American Legion against American Humanists Association. It presented the question whether a 40-foot-tall cross located on a traffic median in Maryland and maintained by the Maryland National Capital Park and Planning Commission, a state institution, violates the First Amendment's Establishment Clause. Known as the Bladensburg Peace Cross, the monument was completed in 1925 as a memorial to soldiers from the county who died in World War I. The Fourth Circuit Court of Appeals, dividing 2-1, held that the towering monument was an unconstitutional endorsement of religion. The Latin cross, the Fourth Circuit majority reasoned, is not a generic symbol of death. It is the preeminent symbol of Christianity, the symbol of the death of Jesus Christ. The Supreme Court, however, reversed the Fourth Circuit and held that long-standing monuments are constitutional if they are inclusive and non-discriminatory. The Bladensburg Peace Cross, according to the majority, fit that description. In dissent, I wrote that the towering cross is scarcely secular in character. It is emblematic of Christianity and no other faith. Maintenance of the cross on public land, I tried to convey, made it appear that the state endorsed Christianity and relegated non-adherents to outsider status. State courts, as always, accounted for important issues before the Supreme Court. In Tibbs against Indiana, to take one example, the state Supreme Court had held that the Eighth Amendment's excessive fines clause applied only to the federal government, not to the states. In the case we took up, Indiana had seized, in a civil forfeiture, a car Petitioner Tibbs had recently purchased with an inheritance from his father for almost $42,000. The drug crime to which he had pleaded guilty, and in connection with which his car was seized, carried a maximum fine of $10,000. The question we addressed: does the 14th Amendment incorporate the Eighth Amendment's protection against excessive fines? In a unanimous judgment, we answered yes. Like the federal government, states may not impose exorbitant fines. The court also took up, in the term just ended, 3 cases about gerrymandering, one alleging race-based voter district line drawing in Virginia, and the others partisan gerrymandering in North Carolina and Maryland. We resolved the racial gerrymandering case, Virginia House of Delegates against Bethune Hill, on a threshold standing to litigate ground. Originally allied with the Virginia House of Delegates, Virginia's Attorney General decided against fighting on when a 3-judge district court ruled for the plaintiffs. Virginia House of Delegates, just one chamber of the Commonwealth's bicameral legislature, sought to appeal. We held that the House of Delegates could not alone continue the litigation against the will of its partners in the legislative process, the state Senate and the governor. Concerning partisan gerrymandering, modern technology allows the map drawing party in a state legislature to create a congressional delegation dramatically out of proportion to the actual overall vote count. In North Carolina, for example, in the 2016 election, Republicans won 53% of the statewide vote, yet they won 10 of the 13 congressional seats. The disproportion continued in 2018, even though in that year, Democrats won a slight majority in the state's congressional district. In North Carolina, a Republican-controlled state legislature drew the maps. In Maryland, Democrats controlled the state legislature and conspicuously drew congressional district boundaries to favor Democrats and dilute Republican votes. Partisan gerrymandering unsettles the fundamental premise that people elect their representatives and not vice versa. The court, however, held that partisan gerrymandering claims present non-justiciable political questions. Justice Kagan, in a strong dissent I joined, along with Justices Breyer and Sotomayor, urged that courts indeed should provide a check against extreme partisan gerrymanders of the kind presented in the North Carolina and Maryland cases. The lower courts, whose judgments were overturned by the Supreme Court, had done just that. Looking ahead to next term, the court has granted review in New York State Rifle and Pistol Association against City of New York to decide whether city laws regulating the transport of handguns past constitutional inspection. We have also taken up Altitude Express against Zarda from the Second Circuit and consolidated it with an 11th Circuit case, Bostock against Clayton County, to resolve a circuit split on this question. Does the ban on employment discrimination on the basis of sex, contained in Title VII of the Civil Rights Act of 1964, does it encompass discrimination on the basis of sexual orientation? The same day we granted review in Zarda and Bostock, we also agreed to review R.G. and G.R. Harris Funeral Homes against Equal Employment Opportunity Commission, a case in which the Sixth Circuit Court of Appeals held that Title VII prohibits employment discrimination against transgender individuals. Another case for next term, Ramos against Louisiana. We will revisit an earlier decision in a case called Apodaca against Oregon, which held that a state court conviction by a non-unanimous jury does not violate the Sixth Amendment's jury trial guarantee, as that guarantee is incorporated by the 14th Amendment. Ramos was found guilty of second-degree murder by a 10-2 jury verdict. He asked us to overrule Apodaca and hold that the Sixth Amendment requires jury unanimity in state as well as federal criminal trials. I can say just one thing about next term. It is safe to predict that we will have a fair share of closely watched cases. Okay, we have the green light.
Well, thank you. Thank you for those remarks, Justice. If I could, I wanted to begin with your remarks on Justice Stevens, which I find difficult to read or listen to without choking up. And I'm wondering why his passing has elicited so much grief. One of his clerks, who is my colleague, Maggie Lemos, said to me that on the one hand, it shouldn't be so sad. He had 99 years, and what a life. I mean, what a life he lived. On the other hand, it is so sad, and part of it is perhaps that when you have someone that decent, that humane, that fundamentally good, it is never easy to say goodbye no matter how long they've lived. But I also wonder whether there's cause to grieve something that he embodied, but that transcends him. And I'm thinking about your invocation of the person conventionally known as Shakespeare. Take him for all in all, we shall not look upon his like again. And what does that mean to you? Right, that this is about more than Justice Stevens, that we shall not look upon his like again.
He was, as I tried to convey, an unusual combination of brilliance and humility. You don't see those two characteristics together in many people. Justice Stevens, as I said, was President Ford's only nominee to the court. But he was the soul of nonpartisan judging. He called each case as he saw it. He had a very independent bent of mind. But there was a geniality about the man, a kindness, a compassion, that to me made him the ideal judge.
My understanding of the backstory behind his nomination actually has a Duke connection of sorts. Edward Levy, the father of Duke Law School's own David Levy, recommended Justice Stevens to President Ford, and he jumped on the opportunity, and Stevens was not recommended because of partisan loyalty or ideological reliability. It was because he was widely regarded as a first-rate legal mind, as a great lawyer, as someone you can trust with that kind of responsibility to give his independent judgment. And I, speaking just for myself, I worry about the extent to which, right, we will not see his like again, right? We're just living in a very different era in which nominees for the Supreme Court are not chosen primarily anymore for independence, right, legal ability, personal decency, and I wonder if that's something, if that's a loss for all of us.
I can say that my two newest colleagues are very decent, very smart individuals. The authority that the president has to nominate federal judges is not trained on the Supreme Court. It's every federal district judge, trial court judge, every court of appeals judge has the same tenure that we do, must be nominated by the president, confirmed by the Senate, and then can remain on the job during good behavior. That's the words of the Constitution. And I worry about it too, Neil, because I remember back to when my dear friend Justice Scalia was nominated by President Reagan. He was his views were well known. He had been a law professor for years. He had been my buddy on the D.C. Circuit, D.C. Court of Appeals. The vote was unanimous, no negative votes. Some years later, in 1993, President Clinton nominates me. I had a history of being a flaming feminist. I was...
You weren't that flaming.
So, I was general counsel to the American Civil Liberties Union.
A lot of feminists criticizing you for not being flaming enough.
but there wasn't, the vote for me was 96-3.
Right.
And the next year for Justice Breyer was also in the 90s. Mm-hmm. And then the Senate began to react differently, and it was true when there was a Democratic Senate as now with a Republican Senate. So some of my very able colleagues, the vote was very close. 30-odd negative votes for Justice Sotomayor and Justice Kagan, same for Justice Alito, most recently Justice Kavanaugh. That trying to figure out how the nominee will vote on the court, instead of asking, does this person have the qualities it takes to be a good judge? Well, my hope is that we will return to the way it once was and the way it should be. I still think that someday there will be patriots on both sides of the aisle who say, enough of this dysfunctional government. We will get together and try to do the business that a national legislature should do.
Did you have a favorite Justice Stevens' opinion, either majority or dissent or top 2 or 3?
He served, 35 years, so it's hard to pick out 1 or 2. But of the decisions that I joined him and felt very strongly about, Citizens United, corporate spending on political campaigns, according to the majority, couldn't be limited because the First Amendment protected their right to speak. I think there's no country in the world that spends the money that we spend on political campaigns. And so I thought the Justice Stevens' opinion, who said it is compatible with the First Amendment to have controls on campaign spending, was absolutely right. Another of his decisions that I thought was great, the government initially took the position that Guantanamo Bay was no man's land. Therefore, our Constitution didn't apply there. And Stevens wrote the decision, I think it was Rasul, saying, Guantanamo Bay is not no man's land, and it isn't controlled by Cuba. Cuba has no say in what happens on that land leased to the United States. To the extent that there is law, it is U.S. law. And so the Constitution does apply to Guantanamo Bay, and the treatment of the people there has to comply with basic tenets of due process.
What about this past term? Would you identify, say, the best decision of the term, the worst decision of the term?
There are so many.
That's the beauty of being a Supreme Court justice. You don't have to limit yourself to
No,
one.
I thought one nice opinion, the one that I described, the Tibbs, of the man who served his time, paid his fine for his drug offense, and then his car is taken, although the car is worth much more than the fine that he had already paid. I thought that was a very good decision. The court was unanimous in saying that the states, just like the federal government, the states can't impose exorbitant fines.
Right. The Land Rover was worth, I think, about 10 times the maximum fine the state could impose. And so, although, states they raise a lot of money this way. So,
yes, it's very tempting to use civil forfeiture.
So they may have faced difficult questions about raising taxes and maybe distributing the burden more equitably. I would have thought one of the most significant ones was the census decision, and one of the ones that someone like you would be most troubled by would be the gerrymandering decisions. Those were the ones I would have named.
Well, the citizenship decision came out right. The Census Bureau analysis was, what is the object of the census? It is to count all of the people who dwell in the United States. And if you're going to put the citizenship question on, there will be people who won't answer, even if they are citizens, because there may be non-citizens living with them in their household. So if the object of the census is to count everyone, then you don't want to put on a question that will intimidate people or lead them not to answer the census questionnaire. There was an excellent opinion, I thought, by the district judge who first heard the case, Judge Furman in the Southern District of New York. And it's one of many examples how the Supreme Court is enlightened by what judges in the courts that heard the case before it came to us, how much we benefit from their opinions. The gerrymandering case, it's very disheartening if you're in a district and you know that it's been rigged, so no matter how you vote, it's going to come out for a certain party. So your attitude is, why bother to vote? My vote won't count. That's, I think, destructive of a democratic system.
Mm-hmm. And it's been around forever, but the computer technology that allows it to be conducted with surgical precision has not been around forever.
Right. But there are some hopeful signs. Some states, I wrote the opinion a few terms before in the Arizona nonpartisan commission. People dissatisfied with the way the legislature has been drawing lines, come up with a referendum, put it on the ballot. The referendum is to have a nonpartisan commission do the district line drawing instead of the Senate. And the Supreme Court said that's okay. You can have a nonpartisan commission do the job and take it away from the state legislature. So with Arizona, California, and now there are a handful of others, that device won't work in states that don't have referendum. Most states don't. But that's an example of the people speaking, the people fed up with something that is not right and saying, we will change it, we will exercise. I mean, the government is supposed to be for we the people. That's how our Constitution starts. So that I think is one way more and more states will go. And then there are some states that under their own constitutions, Pennsylvania is an example of that, who say partisan gerrymandering is not the way a democratic system should work.
Mm-hmm. So abstracting from the particular decisions and looking at the term as a whole, I detect several themes that I'd be interested in your reaction to. One had to do with prudence in leaving things undecided for now. There were a number of very important questions that the court either didn't decide at all or postponed until next term. It seemed to me, at least, that there was some effort to keep a lower profile. Another theme had to do with the presence of ideological division. The court was quite divided in a number of important cases, but the divisions were not the so-called ideological splits with the conservatives on one side and the liberals on the other. I mean, you had cross-ideological coalitions. And a third theme I saw was a lot of debate about the role of the institution of stare decisis, the fidelity to precedent, and arguments for and against its important as essential to the vindication of rule of law values. And I myself am wondering whether this sort of talk is characteristic of a court in transition, and the next term and the term after that are going to be very different, or whether this is the beginning of a longer-term trend of the court trying to make good on the Chief Justice's insistence that we don't have Obama judges and Trump judges. We have judges, right? There's a reason why they wear black robes and not blue robes and red robes. And we can't know, only time will tell, but I'm wondering if there's any thoughts you'd want to share on that this term was not, was much less ideologically divisive than Justice Kennedy's last term, for example. And what sense one could make of that, if any, or if we just can't know at this point.
The first of your three observations was, what was?
That the court was divided. Oh, the first was about leaving things undecided, right?
Yes, and that's, I think, for the most part, a wise way for a court to proceed. We can't see down the road of what will be the next development. Mm-hmm. And it ties into something I try to convey, which is we are benefited by what the word we use is percolation. A difficult question of federal law comes up. If we have only one return from lower courts, we will not be as well informed as if we allow the question to stay in the lower courts for a time longer. Then maybe we'll get 3 opinions on one side, 2 on the other, and we will be better informed, better prepared to make the decision. So not rushing in to decide the first case that comes up, to wait till there are other returns. And I'm glad you brought up that there have been a number of cases this term where we didn't divide along so-called party lines. I mean, the keen observers of what the courts do will have noticed that I assigned an opinion this term to Justice Kavanaugh and 2 to Justice Gorsuch. And that meant that the Chief Justice and Justice Justice Thomas had to be on the other side because I'm number 3 now. So I get to assign an opinion only if the Chief and Justice Thomas are on the other side.
It didn't seem random that you did that.
Yes.
Right. That it was. Yeah, and that's quite a plum assignment for Justice Kavanaugh to write that major decision in the Apple case. Yeah. And there were a number of that. I think there were 2 by the Chief, 4 by Justice Gorsuch, 1 by Alito, 1 by Thomas, right, in which you had them joining majorities consisting of one of them and you, Justices Breyer, Sotomayor, and Kagan. And that's what I meant. There were plenty of divisions, but not a sort of partisan ideological characterization one often hears, and I pray we'll see more of that in the years again. We'll just have to see. What can you tell us about the atmosphere inside the recently reconstituted Roberts Court?
The court remains the most collegial place I have ever worked, and that includes law faculties. In my 13 years on the D.C. Circuit, all of those were collegial, but not to the extent that the court is. We have certain traditions that help promote collegiality. For one thing, the handshake. Every day that we sit to hear oral argument or to confer on cases, first thing we do is we go around the table in the conference room. Each justice shakes hands with every other. It's a way of saying, yeah, you circulated a pretty nasty dissent yesterday, but we're all in this together, and we revere the institution for which we work much more than our individual egos. There's a lot of togetherness on the court. We have, as an extracurricular benefit, twice a year we have musicals at the court. In this most recent one in May, we had Joshua Bell, Jeremy Denk, and Stephen Isserlis. And in November, we will have 2 great Metropolitan Opera singers. Whenever it's a justice's birthday, we have lunch together and we toast the birthday person. I must say that those choruses of happy birthday are not what they were when Justice Scalia was with us, because if truth be told, he was the only one of the 9 that could really carry a tune. So, and when a new justice comes on board, the person who has just relinquished the junior justice spot hosts a dinner in honor of the new member of the court.
So there's really no junior high school behavior, no cold shoulders, no I'm not getting you a birthday present because of that dissent you wrote.
No, and there's no horse trading either. Well, there's no, well, if you vote for me, my side of the case, in this case, I'll vote That never happened.
No one's ever said to you, we're not friends anymore? No? Okay. I'm dealing with the politics of middle school with my kids, so I just am wondering if it's reassuring to know. If I could switch gears, could you speak a little bit to the issue of access to justice, meaning access to the courts to vindicate valid legal claims, and why that's important? I mean, that's been a frequent theme among you and your colleagues over the past, 10 years?
Well, I know from personal experience how important that is when you think of the gender discrimination cases of the 70s. First case, Reed v. Reed, brought by Sally Reed, who had a great tragedy in her life. Her teenage son committed suicide. Yeah. She wants to be appointed administrator of his estate. The boy's father, Sally and the father had divorced, applied 2 weeks later, and the probate court judge told Sally Reed, I have no choice. The Idaho, she was from Boise, Idaho law reads, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. That kind of law riddled the state and federal law books until the decade of the 70s. But here was Sally Reed, a woman who made her living by caring for elderly or sick people in her home. She thought she had encountered an injustice, and she thought we had a legal system that could vindicate her position. So she went through 3 levels of the Idaho courts on her own dime, and it was only at the Supreme Court level that the ACLU came in. But you take every one of those plaintiffs, Sharon Frontiero, Stephen Weisenfeld, these were all everyday people. But they believed we had a fair system of justice and that their complaint would be heard and vindicated. So to have such a system, the courts must be open to people, even people of very modest means, to come to the court to complain.
So I'm hoping you could next help me with a homework assignment. It's the, as I'm sure you know better than most, we're approaching the centennial of the 19th Amendment. And it's a topic upon which I and a number of law professors are going to be writing. And I'm wondering what your thoughts are on why the 19th Amendment matters to Americans today. Now, there's an obvious way, an obvious and profoundly important way in which it matters to Americans today. Because of the 19th Amendment, as well as, we should not forget, eventual effective enforcement of the 15th Amendment, all women, adult citizens in this country possess a federal constitutional right to vote that they did not possess for most of American history. Most people today take it for granted, but it's actually relatively recent history. And so that's an obvious way in which it matters.
The vote is 100 years old, but the struggle to achieve the vote goes back at least 75 years before 1920.
That's right. It's when feminists who work in abolitionist organizations, out of the conviction that if African Americans earned the right to vote, that women would earn the right to vote too, and they were told, sorry, this is the Negro's hour. And then after the Reconstruction Amendments are added, and in fact, the Constitution enshrines a sex classification for the first time in Section 2 of the 14th Amendment, feminists look to the Supreme Court for help through constitutional litigation to obtain a right to vote, and they lose there as well. So yes, you're talking about many decades of contestation and struggle.
And I'm glad you mentioned the abolitionists, because There was a great historian, I think she was at one time president of Duke. I can't remember her name. But she'd come across just dozens of petitions from women in the South to abolish slavery. And she thought, what a find, and I'm going to write about this. And then she discovered that her male colleagues had also come across these petitions, but they discounted them. These were women's petitions, and women didn't matter.
Yeah.
But when you think about what was the opposition to the vote for women, one was they'll just vote the way their husbands tell them to, so it's not going to matter. Or the other is they won't vote the way their husbands tell them to, and then there'll be dissension in the family.
All the while not realizing those are inconsistent objections. Right? Women are virtually represented, or it'll destroy the family if women assert their independence. So yes, I mean, the struggle really begins in earnest with the Reconstruction Amendments, not including voting rights for women. I'm wondering if there are other potentially less obvious ways that the 19th Amendment matters today, and I'm thinking in particular about your magisterial opinion for the court in United States against Virginia in 1996. Right? This is the case in which the court held that the Equal Protection Clause prohibits the Virginia Military Institute's all male admissions policy. Women were categorically excluded from eligibility to apply for admission to VMI, and the court, in your majority opinion, held that this violates the Equal Protection Clause, and it violates the Equal Protection Clause because this policy was reflecting and reinforcing the inferior social status that women had suffered under historically. This idea that women were fit for family life, for a life of caregiving within the home, and men were fit for educational, economic, political life, for a life of breadwinning outside the home. And you mention, suggestively but briefly in that opinion, the 19th Amendment, when you talk about a long history that women have suffered under, and it wasn't until 1920 that women earned the right to vote.
You know the first case, Minor against Happersett?
Yes.
A woman who said, just after the 14th Amendment, she said, well, I'm a person and I'm a citizen, and the most basic right of a citizen is to vote for the people who will represent we the people. So, being a person and being a citizen, I should have the right to vote. And the Supreme Court agreed that she was a person and she was a citizen, but the next line was, but so too are children. And no one would think children should have the right to vote. You know, in the years I was on the D.C. Circuit, I had the great good fortune to get to know a woman named Bernita Shelton Matthews. She was the first woman ever appointed to a federal district court judgeship, 1948. She was counsel to the National Woman's Party, which was the more radical wing of the suffrage movement. And she would describe what life was like for her. She was going to law school at night. She would go to the White House to picket. She would hold up her sign, Votes for Women. She would never speak a word because she didn't want an arrest record to mar her prospects from becoming a member of the bar. She had some wonderful stories to tell, including she hired only women as law clerks. Why? Because her colleagues hired only men. And she maintained that she always had the best law clerks in the court. The headquarters of the National Women's Party were on the land where the Supreme Court now stands. So the government, in order to acquire all that land, had to condemn property, take them by eminent domain, which entitled the owners to just compensation. So the government maintained that this a house that was the headquarters of the National Women's Party was a ramshackle old building, not worth anything really. Bernita Shelton Matthews, whose specialty was eminent domain, argued first this building was the temporary capital when the Capitol burned down in the War of 1812. And then later it was used as a prison for notorious Confederate spies. The government rejected all of that. Bernita Shelton Matthews had a member of the Society of Older Inhabitants who testified on the stand that he remembered this house being used as a jail for Confederate prisoners. And then she introduced a picture of a notorious Confederate spy who happened to be a woman inside that building. And that was the end. The government capitulated, and she won the largest condemnation award that the government, U.S. government, had paid up until that time. She was a woman from Mississippi. She had a soft Southern accent, but she was just a model of wisdom and courage. So that's why I'm optimistic for the long run when I think about how things were like and how far we have come. And it's not just, we start out with we the people in order to form a more perfect union, the opening words of our Constitution. So who was we the people? I would not have been there. The original Constitution preserved slavery. Native Americans were not part of the political constituency. There was the Chinese Exclusion Act. But over the history of this country, this notion of who is we the people, who are we the people, has become ever more embracive. So I think the true genius of the Constitution is that we have been able, sometimes through Supreme Court decisions, sometimes through legislative change, become an ever more inclusive society.
I think that speaks to your disagreement with your good friend Justice Scalia in the VMI case, because you're both relying heavily on history and tradition. But from his point of view, the fact that you have a long-standing history and tradition of male-only eligibility at VMI is itself constitutional warrant to continue the tradition. And you didn't respond by simply saying history and tradition are irrelevant. You rather invoked the constitutional authority of anti-tradition, of negative precedent, right? That there was a long history and tradition of excluding women from voting, and yet that wasn't a reason to continue the practice, right? That was a reason to end it. And just as we did it with respect to voting, maybe we ought to be doing it with respect to other laws and practices that reflect or reinforce women's inferior social status today.
The grand clauses of the Constitution, grand in their generality, due process of law, equal protection of the laws, they were written by people who lived at a time when those grand ideas could not be fully realized. The author of our Declaration of Independence, all men are created equal, was a slaveholder, Thomas Jefferson. They were held back by their times from realizing these grand ideas. But I think if we could somehow communicate with them today, they would say, yes, that's what we meant. We meant these grand themes to have growth potential, to grow with the society.
Yeah, I remember you once wrote that they used words like liberty and equality, and these words had growth potential.
Yeah.
They rejected the patriarchal power of kings. Right? The right to govern didn't rest on birthright, and they had concepts, right, that still remain vibrant today, even if their particular conceptions or expected applications of them are ones that we would reject. That seems to me to be very much the music of your majority opinion in VMI, and I think it helps to illuminate the continuing importance of the 19th Amendment today. I would go so far as to say that we should be interpreting the Equal Protection Clause in light of the 19th Amendment. Right? The 19th Amendment declares women's independence from a subordinate role in the family, the idea that they're going to be virtually represented by their husbands. And if that's true of voting, why shouldn't it be true of other matters?
Now, there was an effort to interpret the 19th Amendment to install the equality of women in all fields of human endeavor.
Juries running for office, I remember.
But the Supreme Court turned it down with respect to juries. The argument was the 19th Amendment makes women full citizens. It is an obligation as well as a right for citizens to serve on juries. And the Supreme Court decided that the 19th Amendment gave women the vote, and only that, didn't give them the right to serve on juries.
They read it as a narrow determinant rule, even though for the many decades you mentioned earlier, in these robust debates over the 19th Amendment, what was called the woman question. It wasn't about a narrow decision rule with respect to voting. It was about everything. It was about harmony within the family. It was about preserving state domestic relations law. And so this issue that was about gender roles in our federal structure very quickly became a narrow issue about voting. And I would add, we don't read the First Amendment that way. We don't read the Second Amendment that way. We certainly don't read the 11th Amendment that way. We don't read the 21st Amendment that way. Think about the recent decision from your term on the Dormant Commerce decision that intersected with the 21st Amendment. And so we're actually quite selective about the amendments we read simply as narrow decision rules with a limited compass. And I find it suspect in light of our history that the 19th Amendment is singled out for that kind of disfavored treatment. The reason why I think it matters is because one often hears among educated constitutional law professors who ought to know better that the Equal Protection Clause is really about race. Everyone knows that. The history of the framing and ratification was about African Americans and making citizens of slaves, not women. Well, in fact, that denies women's equality, the dignity, the legitimacy of having a constitutional history of its own right. But you have to look at the decades-long struggle over the 19th Amendment and understand the Reconstruction Amendments in light of it. And that's really a minority view in the Academy. It's one that I would hope you and your colleagues would take more seriously in the years ahead.
Well, the original Constitution doesn't include the word equal. Here we had the Great Declaration of Independence, where the idea of equality is imbued in that document. And yet the original Constitution does not use the word equal. Why? Because of the huge embarrassment of slavery. So then when the 14th Amendment uses, nor shall any state deny to any person the equal protection of the laws, then the equality idea that couldn't be in the original Constitution now becomes part of the Constitution. And we have seen the Equal Protection Clause was once thought the last resort of losing arguments.
Yeah, that's Justice Holmes, right? Yeah, the last resort of a loser.
But that's certainly not the case today.
Yeah, that's right. That's right. I'll switch gears again. Any thoughts on the importance of showing respect for others as part of a commitment to diversity, or even if that's not your cup of tea, as just being part of a good person as well as a member of a diverse political community? Why is it so important to act and speak in ways that demonstrate respect for others, especially others who you don't regard as especially similar to you?
Well, that respect and readiness to listen to others were typified Justice John Paul Stevens. He called it learning on the job. Mm-hmm. And he was a very good listener. And nowadays, when people divide into, I'll talk to my own kind, and the others are, I have nothing to do with them. That's very sad, because that hasn't been the way it was. And it isn't the way this country should be. Mm-hmm. I mean, beyond just mere tolerance of different views, welcoming different views because they enrich our society. I know from in my own work, there's nothing better to improve a majority opinion for the court than a really effective dissent, because it'll point out all the soft spots in the opinion, and then the majority opinion writer can improve.
Didn't you always prefer a Scalia dissent?
Yes.
Because he was so analytically sharp.
Yeah.
Right? Yeah. Yeah. Are there forms of what I like to call constitutional patriotism that you would commend to Americans during current polarized times? We all love our Constitution, even as we disagree profoundly about what it means and what it says we owe one another. Any good ways of sustaining community social solidarity amidst rampant tribalism that you would have us think about? I mean, what comes to my mind is your beautiful friendship with Justice Scalia, which I'm not sure made a lot of sense to either of your friends, but it made a whole lot of sense to the two of you. You mentioned his confirmation vote, your confirmation vote. I would add the role of Republican Senator Orrin Hatch in your successful nomination.
Senator Orrin Hatch from Utah was my biggest supporter on the Judiciary Committee. He was the minority leader. Biden was the chair of the Judiciary Committee. Well, that kind of bipartisan spirit is the way it should be, and the way it was not very long ago, and the way I hope we will see again in my lifetime. With Justice Scalia, we had a lot in common. For one thing, we both had a passion for opera. For another thing, we really cared about family. And a third, we cared very much about not just simply the result you reach in a case, but how you write the opinion. Now, we had very different writing styles. Even so, every once in a while, Justice Scalia, although he had 9 children, he was an only child, and his mother was an elementary school teacher. So he was very well schooled. Oh, I should say his father. His father was a teacher of Latin. He was a professor of Latin at Brooklyn College. So Scalia was an expert grammarian, and every once in a while he'd come to my chambers, or he'd call me, and he didn't want to embarrass me by sending a note and circulating it to my colleagues, but he'd say, "You made a grammatical error."
Was he right?
Yes, he was always right. Then I would tell him, "This opinion is so over the top, you're going to lose people. You'll be more persuasive if you toned it down." Oh. That advice was not received.
That I'm aware of. Were you ever tempted to respond in kind?
No,
to some of his
it
more
just-
vicious barbs?
It's.
Although
I
you
mean,
didn't really direct them so much at you.
Well, we did in the Virginia Military Institute case. There were a few zingers in there,
Yeah.
including. I had referred to the University of Virginia at Charlottesville. He came back and said, "There is no University of Virginia at Charlottesville. There is only the University of Virginia."
Just ask anyone who went there.
For the next version, I put the University of Virginia at Charlottesville in quotation marks, citing an opinion by Judge Merritt, who was the district judge in Virginia.
Any message you would like to convey to young women, or perhaps to young men?
Well, if you're thinking about the law as a profession, I'll tell you how I was attracted to the law. I was going to college in the heyday of Senator Joe McCarthy. Not a good time for our country. There was a huge Red Scare, and people were being brought before the House Un-American Activities Committee or the Senate, the parallel Senate committee, and quizzed about some association they belonged to in their very young days in the height of the Depression in the 1930s. I had a professor for constitutional law, Robert E. Cushman, who pointed out to me that we were straying very far from our most basic values, in this case, the First Amendment, the right to think, speak, and write as you believe, and not as a big brother government tells you is the right way to think. Mm-hmm. And there were lawyers standing up for these people, reminding our Congress that we had a First Amendment protecting freedom of expression, a Fifth Amendment protecting us against self-incrimination. So I got the idea then that being a lawyer was pretty nifty. You know, you could get a job that paid you, but then you could use your skill to make things a little better in your community by representing people who needed representation. Mm-hmm. So I think the dual aspect of law, you can earn a living, but you can also do something outside yourself that will make things a little better for people who are less fortunate than you.
Who are your heroes, Justice?
Who are my heroes? Well, growing up, I didn't have very many because the women weren't out there doing things. I'd say the two that I thought I'd like to be like. One was real, the other was fictional. And the real one was Amelia Earhart. Mm-hmm. And the fictional one was Nancy Drew. But now there's so many women out there doing everything in every field of human endeavor. I had lung cancer several months, the beginning of this year, and my thoracic surgeon is a woman. She was just elected to be the head of the American College of Surgeons. That women this year the Washington Opera had three different operas, 3 women as conductors. Things that women did but went unsung, and many women composers nowadays. And we're all the better off for it. It's what Justice O'Connor used to say, the first thing women who want to make things better should do is to get out there and do things. And the more women who are out there doing things, the more society will see what women can do, women will see what women can do, and we'll all be better off for it.
Any men who you regard as heroic figures? I mean, it's men who vote for the 19th Amendment.
Yeah, I was thinking of the court, the great Chief Justice John Marshall, who explained the idea of judicial review for constitutionality that no high court in the world at that time was doing. He's certainly one of my heroes. And I love the biography of him by Jean Edward Smith. Holmes and Brandeis, around the time of the First World War, and their free speech decisions. Wow, and I really have to say that I was blessed with having a most unusual marriage to a man who believed that my work was at least as important as his, who was always my biggest booster. I think I would have turned out to be a very different woman if I hadn't married Marty.
I'll ask you one more question, but I think Justice Stevens already preempted it. I'll ask it anyway. Do you plan on staying in this gig for the next couple of years, or would you like me to prepare for you a letter of recommendation?
I've always said I'll stay on this job as long as I can do it full steam. And that means at my age, 86, you have to take it year by year. So I know I'm okay. I was okay this last term. I expect to be okay next term. And then after that, we'll just have to see.
Well, Justice, I think Stevens demonstrated that 86 is the new 76 at the Supreme Court of the United States. And whenever I have colleagues who complain about how old they're getting, I reassure them that they are infants by Supreme Court standards. And that seems to assuage the anguish of their bereavement. Well, Justice, thank you very much once again for being so generous and spending some time with us this evening. I would ask everyone in the audience, before you join me in thanking the Justice yourselves, to please remain seated so that the Justice can make her way to the exit safely and expeditiously. Thank you, Justice. Thank you so much.
Let's retrieve what's on there. Okay. Oh yeah, we should take this one.
The mic is on.